The first and the foremost being the destruction of the subject matter. The doctrine of impossibility applies with full force where the actual and specific subject matter of the contract has ceased to exist. For example, in Taylor versus Cadwell, that is the defendant, agreed to let Taylor, the plaintiff, have the use of Surrey Gardens and Music Hall for the purpose of giving concerts on 4 designated days in the summer of 1861. The plaintiff had agreed to pay £100 for each day. After making the agreement and 6 days before the first day on which the concert was to be given, the hall was destroyed by an accidental fire. The destruction was without any fault on either party and was so complete that in consequence of it, no concert could be given as intended. The plaintiff brought an action against the defendant for damages for breach of contract, which the plaintiff was unable to perform through no fault of his own. The defendant was held not liable to pay. Justice Blackburn, delivering the judgment, observed, I quote, "The principle seems to us to be that the contract in which the performance depends on the continued existence of a given person or thing, a condition is implied that the impossibility of performance arising from the perishing of the person or the thing shall excuse the performance." Unquote. The second ground is death or personal incapacity. Death or personal incapacity will generally render the contract frustrated. A party to a contract is excused from performance if it depends upon the existence of a given person if that person dies or becomes incapable to perform. Robinson versus Davison is a well-known illustration. There was a contract between the plaintiff and the defendant's wife, who was an eminent pianist, that she should play the piano at a concert to be given by the plaintiff on a specified day. On the morning of the day in question, she informed the plaintiff that she was too ill to attend the concert. The concert had to be postponed and the plaintiff lost a sum of money. The plaintiff's action for breach of contract failed. The court said that under the circumstances she was not merely excused from playing, but she was also not at liberty to play if she was unfit to do so. The contract was clearly subject to the condition of her being well enough to perform. In Conder versus Baron Knights, a 16-year-old boy agreed by contract to play the drums for the defendant's band for 7 nights per week for 5 years. The claimant suffered a mental breakdown and was told by his doctor that he should not perform more than 4 nights per week. The band dismissed him. He brought a claim for wrongful dismissal. The court held that the claimant's medical condition made it impossible for him to perform his contractual obligations, and the contract was thus frustrated. The third ground is change of circumstances. Where circumstances arise so as to make the performance of the contract impossible in the manner and at the time contemplated, the contract will be frustrated. In P.T. Mehra versus Ramchand Om Prakash, the Punjab High Court held that if that be the case, the change of circumstances not having been brought about by the fault of either party, the courts will not enforce a contract. In that case, X entered into a contract with Y to supply certain goods. The contract was CIF Karachi. The goods arrived there after some delay. Subsequently, a dispute arose between X and Y. Y refused to accept the goods on the ground that both the qualities and the quantities offered for the delivery were not according to the particular contract. The dispute was referred to the nominated arbitrator who was residing at Karachi. Then came partition, which made it impossible for non-Muslims to go to Karachi. The court held that the contract was not frustrated because the arbitrator could proceed without the parties' presence. Personal presence of the parties was not required to make the award of arbitration. A contract is not merely frustrated because the circumstances in which it was made are altered. The courts have no general power to excuse a party from the performance of his part of the contract merely because its performance has become cumbersome on account of an unforeseen turn of events. Escalation. Law has to adapt itself to economic changes. Marginal price rise may be ignored, but when prices escalate out of all proportion that could have been reasonably expected by the parties and make the performance so crushing to the contractor as to border virtually on impossibility, the law would have to offer relief to the contractor in terms of price revision. The Supreme Court has recognized this in Tarapore and Company versus Cochin Shipping Yard Limited. In this case, the court held that there is no room for doubt that the parties agreed that the investment of the contractor for import of equipment and know-how in foreign exchange would be 2 crores and the tendered rates were based upon and correlated to this understanding. When an agreement is based upon an agreed fact situation and that situation ceases to exist, the agreement to that extent becomes irrelevant. The rates payable to the contractor were related to the investment of rupees 2 crore by the contractor. Once the rates became irrelevant on account of circumstances beyond the control of the contractor, it was open to him to make a claim for compensation.